All right. It looks like our count has taken a pause with the folks that are coming in. So let's just go ahead and get started. Welcome, everyone. I am Jam Iwuyor, and today this is the Reparation Information Thought Series, where we are discussing today eligibility. This is an eligibility discussion and analysis for reparations in the United States. And the discussants will share their views on frameworks for non-strict lineage standards for reparations in the United States. And I know that wording could be confusing for some. So when we say non-strict lineage standards for reparations, this is not a lineage-based conversation. This would be the opposite of that. The Reparation Information Thought Series is a periodic strategic webinar featuring reparations experts, racial justice thought leaders, and you engaged in critical discussion, reflection, analysis on issues pertinent to the movement for reparatory justice in the United States and abroad, co-hosted by the Reparation Education Project and the National Black Cultural Information Trust. And I am so happy to welcome the guests that we have with us today. Our panelists include Nkechi Taifa, who is a civil and human rights attorney, scholar, activist, talk show host, and author. She is the executive director of the Reparation Education Project, Inc., president of the Taifa Group, LLC, and serves as senior fellow for the Center of Justice at Columbia University and as Power, Innovation, and Leadership graduate of Harvard Kennedy School. Taifa is a visionary thought leader, nationally recognized expert and commentator on race and justice issues. She is the convener emeritus of the Justice Roundtable Coalition and served as commissioner and chair of the DC Commission on Human Rights. She has worked for the Open Society Foundations, Howard University School of Law, the ACLU, Women's Legal Defense Fund, National Prison Project, and as attorney in private practice. She has testified before the United States Congress, the Inter-American Commission on Human Rights, and the U.S. Helsinki Commission, the D.C. City Council, and the Maryland Legislature, the California Reparations Task Force, and the UN Permanent Forum for People of African Descent. Nkechi delivered a powerful TED Talk, Reparations, an issue whose time has come, and is the author of bestseller books, Black Power, Black Lawyer, My Audacious Quest for Justice, Reparations on Fire, How and Why It's Spreading Across America, and several children's books. She has been featured in major print and electronic media and has received numerous honors and awards for her work, including Essence Magazine's Woke 100 Women Advocating for Change. Then we have Maynard Henry Sr. Esquire. He has a journey in the fight for our people's liberation that began before he was born in his mother's womb. He states, I was born in 1961 and attended public and private schools in Philadelphia, Pennsylvania. During my years in Philly, I was involved in the social political movements of the time, from protesting discrimination to urban policy issues and substandard education. Upon graduating from high school, I attended a military academy and was commissioned in the United States Marine Corps. After leaving active duty, I practiced law at a firm in Detroit, Michigan, and lived and studied under my uncle Milton Henry, affectionately known as Gaidi Obadeli, brother of Imari Obadeli. Over the years of practicing law, I was also further groomed in the fight for the liberation of our people by Dr. Obadeli. I have dedicated my practice and my life work to seeking justice for those who are disenfranchised and have heavily focused my practice on civil and human rights and criminal defense. In law school, I was president of the Black Law Students Association. I am a member of the NAACP, the National Bar Association, the Urban League, and the Northern Virginia Black Attorneys Association. I am a former National Legal Strategies co-chair for NCOBRA and serves as the legal advisor for the NCOBRA board and a member of the NCOBRA International Affairs Commission. Former chair of the NCOBRA International Affairs Commission Plebiscite Committee, International Civil Society Working Group for the United Nations Permanent Forum of People of African Descent, and plaintiff's counsel in the current Tulsa race massacre litigation, and served as the presiding judge for the Special People's Court of the Republic of New Africa. So welcome, Maynard Henry Sr., Esquire. We also have with us Lisa Holder, Esquire, who is the president of the Equal Justice Society, an Oakland, California-based organization transforming the nation's consciousness on race through law, social science, and the arts. She is a past commissioner on California's Reparations Task Force and current co-founder of the Alliance for Reparations Coalition and Truth, whose mission is to educate the public about reparations, amplify the California Reparations Task Force's report and its recommendations, achieve broad-based multiracial public support of reparations, and grow the base of multiracial and multi-sector allies who support reparations in California. Lisa Holder is a nationally recognized award-winning trial attorney who has been identified as a super lawyer by Los Angeles Magazine for 4 consecutive years. She has dedicated her career to racial and social justice and systems change. She periodically teaches the Civil Rights and Police Essentiality Clinic at UCLA Law School. She served as a legislative consultant in institutional bias elimination, drafting California's bias elimination laws, and testifying as a subject matter expert in the California Assembly and Senate. In 2019, she drafted laws that now require all judges, attorneys, court staff, and health professionals to undertake continuing education on bias elimination. In 2020, she co-steered the Proposition 16 campaign to repeal California's ban on affirmative action. And in 2021, she was appointed by the governor to serve on the California Reparations Task Force. So welcome, Lisa. We also have with us Safiwe Baleka. Safiwe Baleka has been active in the reparations movement since he first joined NCOBRA's Chicago chapter back in 1997. In 2003, Safiwe was in Addis Ababa, Ethiopia, when the African Union laid the basis for the Diaspora 6th region. Since then, his work has been primarily focused in international law and specifically on the right of return of Afro-descendants to their ancestral homelands, a key component of reparations. This work has informed his understanding of self-determination and the status of the Black population in the United States. Currently, Safiwe Baleka serves as the Minister of Foreign Affairs of the Provisional Government of the Republic of New Africa and engaged in the diplomatic work internationally that would support reparations framed through the mechanism of a plebiscite. Welcome, Safiwe. So thank you so much to everyone joining us today. It's just amazing to be able to join on a Tuesday afternoon and get down to the nitty-gritty of what everyone has been talking about, which has been reparations in America and eligibility. And so we're going to start it off with our first question. I'm going to start with you, Nikichi. And the first question is, please explain your stance on reparations and potential eligibility standards.
All right. So thank you so very much, Jam, also known as Jessica Ann Mitchell for moderating this. And I just want to, as part of my 5 to 7 minutes, I just do a little of the framing as to how this a particular episode of the Reparation Information Thought Series came about. So in my book, Reparations on Fire, How and Why It's Spreading Across America, on pages 56 to 57, I proffered a recommended criteria for reparations eligibility for consideration and discussion. And I stated that my recommendation was admittedly without the benefit of collective dialogue and analysis, because reparations is today, as my title denotes, spreading rapidly across America, and because there are some advocates who have united on a very strict lineage standard. I critique that standard in my book, Reparations on Fire, on page 53 to 56. But I felt that it really was past time that the reparations community that might not 100% agree with a strict approach to eligibility based on lineage, engage in collective discussion, and hopefully unite, or at least put various positions on the table with respect to a common definition of reparations eligibility. And so I sent a request out for feedback. My approach to reparations eligibility to a list of advocates that I've either worked with over the past years or recently, or was otherwise familiar with their work as part of the reparations movement. And I asked them to review the passage, which I'm about to share from Reparations on Fire, and to discuss if needed, with their organization or with their colleagues or with their thought partners, and let me know their views. And the people who are who's sharing this platform with me are some of the people who responded to that survey that I sent out. So the relevant passage that I had proffered, again, without the benefit of any type of collective discussion or anything along those lines, stated as follows. And I'm just going to share it. I said, I did not address the issue of eligibility for reparations as part of my testimony before the California Reparations Task Force because I am still developing my philosophy. This was written in, whenever my book came out, I forgot when it came out, 2022. Okay, the end of 2022, that I was still developing my philosophy and opinions on the subject. I said, I do feel that Black people should not be pigeonholed into an under-inclusive class of eligibility for reparations, that a more fair and just approach should be an inclusive framework that does not punish those who, through no fault of their own, could not supply the requisite proof of lineage. As such, but immediately without the benefit of collective dialogue and analysis, I now proffer the following criteria for consideration and discussion. Quote, all people recorded as Black in the 1970 census, that was the first census after passage of the 1964 Civil Rights Act and the 1965 Voting Rights Act, when the most egregious racially discriminatory laws was ostensibly eradicated, I say ostensibly, and their descendants will be eligible for direct, i.e. cash reparation payments in the United States at an amount determined by the official commission or task force studying and developing reparation proposals. Such period encompasses both the enslavement and Jim Crow U.S. apartheid eras, with their attendant health, wealth, education, cultural, and punishment atrocities, abuses, and disparities, as well as the obliteration of the right to self-determination of a political future. All Blacks, including those described above, i.e. everyone that I just mentioned, as well as those entered into the U.S. Census after 1970, will be eligible for community/group/collective reparations in whatever form or forms are determined by the official commission or task force studying and developing remedies. This is in recognition of the continuing harms, living legacies, and new manifestations emanating from the enslavement and Jim Crow apartheid eras, and also expressly including the era of mass incarceration, which manifested post-1965. I stated that the above eligibility approach relates to the federal level only, because there are different circumstances based on the unique histories in cities and states. No one redress effort fits all. Also, this method does not negate specific descendant-based reparatory justice claims to be addressed on a case-by-case, family/neighborhood or community basis and adjudicated as such. So, Jim, I'm going to close. At that point, I didn't time myself, but hopefully I was within my 7 minutes.
Yes, right there. So next up, we would have Maynard. Please share your stance on reparations and potential eligibility standards.
Thank you, Jam. Thank you, Nkechi, for that dialogue there. And I think your points hit the salient issues. One of the things I want to just add to that before I start my discussion is just prefacing with, as a lawyer, I always like to hone in on the issue and try to simplify it as well. So who is eligible for reparations in the United States for chattel slavery and its vestiges? My short answer is I would like to see it more inclusive than exclusive, namely not a limited basis based on lineage. That is problematic, and without getting into a detailed discussion as to why that is problematic, just know that it opens a plethora of problems for those that cannot identify their lineage due to the fact that we had chattel slavery, and so we were not counted as human beings, and so therefore we don't have an accurate basis to determine our exact lineage for many of us. On a broader issue, I just like to also state this. Our history, as many of us know, does not begin with slavery. It begins in Africa, where we were once kings, queens, warriors, scholars, healers, and leaders. And as Sheila Jackson Lee said, the discussion of reparations begins with chattel slavery, but it does not end there. That is only the beginning of the discussion. Chattel slavery is the beginning of the discussion. And I indicate and point out that the repair must be broad in scope and broad in eligibility, because the harm is broad in scope and the injuries are generational. And when I say generational, we're talking about 3 and 4 generations back, and 5 and 6 and 7, 8 generations still down the road. When we look at chattel slavery and the 200 plus years of actual bondage, and when we look at chattel slavery of not being in bondage as far as the chains, but we're talking about the vestiges of slavery, we're talking about 500 plus years. And so from a remedy point of view and who is eligible, we're talking about at least a class that goes 500 years into the future. If there's a specific harm, there needs to be a specific remedy. And so that specific remedy is also about eligibility. Now, I want to talk about eligibility very quickly, just by giving an example of, whether you're black, white, consider yourself black, you consider yourself white, or you consider yourself black. One of the things that I actually litigated with Dr. Obadeli, General Rashid, and Brother Lajagun, that ultimately made it to the Supreme Court, but was rejected on certiorari, is the fact that race is a construct that is made up. And so how do you define yourself as black, white, or other? And so we definitely cannot just have it limited on what we perceive to be a complexion of your skin tone. And also, when we're talking about whether you're an immigrant or not, do you receive it or don't receive it? Let me just point out this example, then I'm going to turn it over to back to Jam for our next panelist. If you remember the killing of Amadou Diallo back in 1999, I think it was February of 1999, he was a 23-year-old Ghanaian. The New York City cops, when they shot at him 41 times and 19 bullets hit him, when he was shot at and killed, executed on the streets of New York, those cops did not walk up to him and say whether he was black or whether he was from Africa. And so no one is going to walk up to you and make a question before we shoot you, before we decide that we're going to discriminate against you, whether you're Jamaican, whether you're black, whether you're African descent, because our diaspora is broad. And so for discussions of this purpose, I would say that we need to have a very inclusive, very broad category for those that are eligible. And I turn it back over to you, Jam.
Thank you. Next up, we would love to hear from you, Lisa.
Good afternoon, everyone, and thank you for inviting me. It's a pleasure to be in community with you all. I run a national legal organization, and we litigate cases. We litigate cases that are under the Equal Protection Clause of the Constitution. We litigate cases having to do with racial and social justice. We also do legal advocacy. So outside of the court, we're also in front of legislators, you know, advocating for legislative policies that expand human rights and civil rights and ensure that we are pushing back legislatively on policies that are anti-Black and institutionalized racist and racist policies. And then we also do a lot of work around public education. So the hallmark of the work that we do at Equal Justice Society is really about social science, about leveraging social science and evidence to change the nation's consciousness on race and to expand civil rights and to push back on anti-Black policy and practice. Social science has to really be the underpinning for any policy, especially any policy that is going to undergo judicial scrutiny at some point. And so social science needs to be the underpinning for reparations. It needs to be the underpinning for eligibility. The social science that we are able to gather over the last 15 years, and the social science that we certainly gathered on the California Reparations Task Force, shows definitively that continuing racism, the vestiges of slavery, institutionalized racism, stems from anti-Black discrimination, stems from anti-Black animus, and stems from a narrative of anti-Blackness that goes back to 1619. And it's very important to understand that that narrative of anti-Blackness was actually the driver of slavery, not the other way around, right? And so when we are thinking about repairing the harm of 400 years of discrimination, we have to go to its root cause, which is anti-Blackness. And if you're going to use anti-Blackness, if you're going to garner that social science and you're going to use that narrative, then you have to have an expansive reparations that deals with the harm of having Black skin in America. If you have a narrow eligibility criteria that is only based on lineage, you miss out on a massive percentage of that harm, right? Because when you focus on anti-Blackness, you're focusing on harm-based reparations. And we need to make reparations as inclusive as possible. We need to ensure that it is harms-based, and we need to make sure that once we do get reparations, that it is curing the pathology of racism. And you cure the pathology of racism in this country by going to its root cause, which is anti-Blackness. The last thing I will say on this is I'll use an analogy. When we are dealing with any kind of medical or biological pathology or something like a pandemic, what do scientists do? They find patient zero. That's how you cure the pathology. You find the original patient, and then you use science to create a cure for the illness, for the disease. In this country, we have a disease of anti-Blackness. We have a disease, we have a racial pathology, and all of the hatred that we're seeing against other groups, not only Black people, but Native Americans, Asian, AAPI, Latinos, it all stems from the original hate, which was the hate against Black people based on the color of their skin, Blackness. So using that scientific construct of healing, of how you heal a pathology from a science base, you have to go to patient zero. And that's Blackness, that's anti-Blackness. And so we have to make sure that we are staying focused on the cause of the harm, which is anti-Blackness, much more expansive than just lineage.
Thank you so much, Lisa. Safiwe, are you here? We would love to hear
Yes,
you next.
yes, I'm here. Can you hear me?
Yes, we can hear you.
Can you hear me?
Yes,
Okay,
we can
thank
hear
you, Jessica, and greetings to all the panelists and everyone that's gathered. Let me start by apologizing. I am currently in Ouagadougou, Burkina Faso, meeting with the government at a summit. So my internet connection and my bandwidth is not so great. So I have my camera turned off because it's more important that you hear me instead of seeing me. So first off, let me say that I definitely support a simple, clear, common sense approach that eliminates complicated eligibility processes, like the approach that Sister Nkichi had proposed, whereby all people recorded as Black
The Freeway, we cannot hear you.
Okay, I'm back. Can you hear me?
Okay. Yes, we can hear you.
Yeah. Let me start again. I agree with a simple, clear, common sense approach that eliminates the complicated eligibility processes, like the one that Sister Nkichi proposed, where all people recorded as Black in the 1970 census and their descendants. I like that approach. I add to that, however, and this is the part that I agree with Lisa, is that we got to go to patient zero, ground zero. But that ground zero is not located on the slave ship, and it's not located in America. It's actually the original crime, as Malcolm said, you want to solve a problem, you got to go to the origin of the problem. The original crime started when one of our ancestors was ripped from their family and their homeland on the African continent. And that ancestor had an identity that was based on an ancestral lineage, either maternal and paternal. So first of all, part of what I think is the important framework is that we do have to approach this using the plebiscite framework and a self-determination framework, where all people recorded as Black in the 1970 census and their descendants, to begin with, right, are allowed to exercise self-determination by participating in a plebiscite where they get to re-choose between one of four options: returning to Africa, the creation of a new African nation on American soil, US citizenship, or emigration to another country. And that the resources for all of those remedies are made available. And this is important because part of the definition of reparations that we talk about is there has to be satisfaction. So we have to give the people the opportunity to choose, right, one of these remedies. But my approach is dynamic too. And I look at it from the standpoint of international law and what are the legal strategies that have the greatest possibility of being successful right now. So I do support lineage-based approaches as a component and a dynamic reparations legal strategy that could enhance and make the claims stronger. For example, because of DNA testing, we are able to actually identify, okay, you came from this people, you came from that people. And as a result of the fact that we are here as a result of a declaration of war that allowed a military invasion of the African continent that caused our ancestors to be trafficked as prisoners of war. Now that we have the technology to identify where the prisoners of war came from, we can use that under international law, like the Geneva Convention, and we can talk about the Bamileke people or the Bamileke prisoner of war and descendants in America, the Akan prisoners of war enslaved in the United States, the Jola prisoners of war enslaved in the United States. Because part of reparations is repairing that first crime, which is the damage to our lineages. It was our lineages which were the first harms. And like my brother Maynard said, this is the beginning of the conversation. It's not the end. And I agree with Lisa that by the time we get to later periods and we're dealing with reparations, that's where we bring in these maximally inclusive eligibility standards. So I think it's a mixture of both. It's not one or the other. We can use lineage for certain kinds of reparations claims that have legal, great legal effect. And we can use these other, say, post-capture, post-trafficking, post-chattel enslavement when we get into the era of Jim Crow and everything that has happened since. We can use those more inclusive standards to make sure that everybody can get some repair for the harms. So let me land right there.
Thank you so much, Safiwe, and thank you for bearing through the internet complication. We really appreciate you still being able to make it. So the next question is, what are some major misconceptions about what is needed to make wide-scale reparations possible? I'm going to start with you, Nkechi.
Okay, so let me just answer that by talking about some of the problems that I see with lineage-based reparations. And going back to what Brother Safiwe was saying, I will say that being denied of heritage for so long, it is indeed laudable that Blacks scrutinize our ancestry if we choose to do so. However, to legally demand all to do so as a prerequisite to qualify for a reparations benefit, in my humble opinion, is unacceptable, particularly given the many obstacles limiting eligibility to those who can successfully trace their lineage to an ancestor from the enslavement era, while arguably making sense directly after the enslavement era. Is really formidable based on the unconscionable passage of time through no fault of our own, of the almost 200 years later, risking being grossly under-inclusive, discriminatory, and divisive. And I will say that indeed such proof requirement likely necessitates invasive scrutiny of not only likely incomplete 19th and 20th century records of births, deaths, taxes, census reports, property records, but also intrusive genetic DNA tests, attempts to define intraracial biology. And moreover, this hindrance includes the reality of faulty oral histories, the changing of family names, different spellings since the 19th century, and also the fact that many Black people, they simply took great measures to alter their identity, their previous identities, due to abandonment of former slave names and escape from the Ku Klux Klan and other white vigilantes or other acts of self-determination. So to me, that is one of the major misconceptions needed to make wide-scale reparations possible. It can happen, but a misconception is that the only way it can happen is through a strict lineage-based directive.
Thanks, Nkechi. Maynard, we'd love to hear from you.
Yeah, and I agree with that, Nkechi. Misconception, if that means obstacles to lineage, how people are those that are eligible, what they are to do with their reparations from a cash perspective, because reparations is more than cash. But a lot of people say, well, the government's going to give out X amount of dollars to a particular group of people who are eligible for this reparations, and then they're going to go spend it wherever and put it back into the same society that enslaved them. I think that's a misconception. No one makes the argument that when you have a car accident and you are the victim, the defendant, and you sue someone and you get paid, no one says, well, you shouldn't spend your money X, Y, and Z. What you do with your money from that lawsuit, from that remedy is your business. If you want to go out and buy your Cadillac, that's fine. Or I guess people are buying Mercedes and Teslas these days, but you go spend your money however you want to spend it. And so I think for all the naysayers out there as to what happens with cash reparations is obstacle and it divides people. And so I'll end it there on that discussion.
Thank you, Maynard. Next, we hear from Lisa.
Yeah, just in terms of the misconceptions about reparations, which includes misconceptions, but misconceptions, as Maynard said, is a very expansive term. That also includes misinformation, it includes lack of education, it includes disinformation. And so when we're talking about myths and misconceptions, that's the broad, that is sort of the broad bucket that it covers. But the chief misconceptions that I see about reparations it falls into 5 buckets for me. It's number 1, that it is just about a check. Number 2, it's too late. Number 3, it's too few. Number 4, it wasn't me. And number 5, it's too much, right? Very quickly, it's just about a check. Compensation is just one of the 5 components that we need to look at when we're talking about reparations. We're using the international standards on reparations as a critical touch point, and it is important to stick with those international standards because we're going to be most legally viable if we stay within those international parameters. Under those international parameters, we're looking at compensation, rehabilitation, satisfaction, apology, and guarantees of non-repetition. That means you have to ensure that policies and practices are put in place, institutions are transformed so that the harm can never happen again, so that the harm of anti-Blackness actually ceases and desists and never happens again. So you have to think more expansively than reparations is just a check. Reparations is a check plus total systems change. The other misconception is that it's too late. Again, it's too late. Slavery happened 400 years ago. Jim Crow ended 100 years. Jim Crow ended 40 years ago, yada, yada, yada. It's too late. The major response to that trope is that, from an international perspective, when you're dealing with major crimes against humanity, and this slavery and all of its legacies are one of the greatest crimes against humanity that this world has ever seen. Crimes against humanity have no statute of limitations. So the it's too late argument is completely dead in the water from an international human rights perspective. The other argument is that it's too few, which means, you can't just give reparations to Black people. What about Native Americans? What about Latinos? What about LGBTQ? All of those folks have suffered harm from discrimination. Look, I'm open to everyone getting some form of compensation for the legacies of discrimination that they've experienced. But again, African Americans, Black people, we are patient zero. And if you want to get at all the other forms of discrimination that we've seen in this country, you must get to the source. And so it's too few and the whataboutism argument, again, is dead in the water. And another thing to remember from a narrative perspective about that whataboutism argument is that Black people have always opened the door to the expansion of human rights and civil rights, always. But the problem is we've always been left holding that door while everyone else walked through it. And so now it's time to make sure that Black people walk through it together with everybody else. That's what Black reparations is about. And finally, the argument that it's too costly, it's too expensive. So social scientists, economists have studied anti-Black discrimination. And they have found that since the year 2000, anti-Black discrimination has caused a loss in GDP of $18 billion in the last 25 years, $18 billion. So the amount of money that we lose because of the continuation and the entrenchment of anti-Black discrimination as a nation is exorbitant. So it's not too much. The fact is that if you don't do reparations and finally cure this harm, you are losing too much as a nation. It's much more costly to not do reparations than it is to do reparations. So those are sort of the misconceptions that I see across the board that I'm trying to address.
Thank you, Lisa. Safiwe, are you still on the line with us?
Yes, I am. I am here. I agree with what the other panelists have said about the misconceptions. The one that I would highlight and emphasize, though, is that that you can have reparations without dealing with the essential condition before the crime happened. Repair is what? Repair to the condition before the crime happened. Before the invasion, before the capturing and trafficking of the prisoners of war, our ancestors did not live under alien domination. And so I think the misconception and the thing that we don't talk enough about in the reparations movement is that aspect of NCOBRA's harms where they talk about nationhood and peoplehood. The biggest misconception is that we can't have a nation of our own, that's some kind of crazy talk, that we can't have, we are a subjugated nation, an internal domestic colony of the United States that has rights under the International Covenant on Civil and Political Rights. We have the right to self-determination. We have the heritage and history of being connected to this land in the United States and a specific territory within that land. I think the biggest misconception is that we can't assert and talk about our right to self-determination and establishing self-governing territories or independent territories. Remember, at the moment of emancipation, President Lincoln recognized that right and set aside territories for us to set up self-governing colonies that would lead to independence. So again, there's this misconception that we can talk about every other form of reparation, but not national independence. And we need to infuse the reparation movement with the peoplehood the peoplehood, nationhood aspect of the repair. I'll end there.
Thank you, Safiwe. So our next question is, and then after this question, we're going to get to some of the questions in the Q&A. And for everyone, this webinar lasts until 2:15. And so we usually run out of time, but maybe we'll be able to get to as many questions as possible today. So the last question from us, from me as a moderator, is what are your thoughts on the Constitution being used to potentially limit access to reparations? Nkechi, I'll start with you.
Okay, so actually, I would like to respond to that question in the reverse order, because I know my esteemed colleagues, particularly Lisa Holder, is going to have some expert information on that. I would like to speak to my thoughts on the Constitution being used to potentially expand access to reparations. And I say that because I want to, instead of going to the 14th Amendment, which is the limiting part, which I know my colleagues will address, I want to address the 13th Amendment. Aside from that ridiculous prison slavery clause, is neither slavery nor involuntary servitude shall exist in the United States except blah, blah, blah. But the mere fact that the Constitution acknowledged the international human rights of African people who were previously enslaved on this opened up a whole new realm. And a lot of that realm is what Safiwe talked about, but it's the realm of the right to self-determination, to determine for ourselves what we want our political future and destiny to be, to determine that future with what any people should have after a great injustice or harm or genocide has been perpetrated against them, and that is the right to reparations. So whichever one of those aspects of a self-determining future, i.e. repatriation, i.e. immigration somewhere else, i.e. Accepting the 14th Amendment's offer of citizenship and striving to make a multiracial democracy real, or establishing an independent Black nation state on this soil, negotiate with the Native persons and, et cetera. So again, that to me is an expansive way in which we could and should be looking at the Constitution as opposed to the limitations. So I'm going to give it back to you, Jam, for my colleagues to talk about those limiting aspects of the Constitution.
Okay, so Lisa, we'll go straight to you.
Okay, I do want to actually highlight something critical that Nkechi said, and it really is sort of underrepresented in these conversations. The 13th Amendment is actually a critical constitutional force for reparations, because the second clause of the 13th Amendment does say that Congress shall make laws that ensure that the badges and incidents and vestiges of slavery cease and desist. That's in the text of the Constitution. And so it really is a very sort of expansive power that legislators have. And it is codified in the Constitution. So that will definitely be a critical argument if reparations ever comes under judicial scrutiny. And in order to make that argument viable, you have to make sure that you create a reparations program that is focused on the badges and incidents and vestiges of enslavement, right? So you have to look at slavery itself, but you also have to look at its continuing legacy up until this very day. What are the current badges and incidents of slavery, right? And racial profiling is categorically a badge and incident of slavery. And so anything that comes under racial profiling, whether it is in the criminal legal system, whether it is in the healthcare system, whether it is in the education system, under the 13th Amendment, our legislators are required to legislate against those badges of incidents of slavery. So that's a huge plus, and that's a huge win if it is litigated and argued properly. The other thing, though, from a 14th Amendment scholarly perspective, that's really what everyone looks at, and that's sort of when folks say, "Oh no, you have to use lineage because otherwise you're going to deal with strict scrutiny." Frankly, as someone who's actually a constitutional scholar who actually litigates cases in front of judges under the 14th Amendment, frankly, lineage is going to be very transparently a race-conscious approach. And so you're still going to deal with strict scrutiny, which is the highest level of scrutiny, whether you bring reparations as a lineage-based program or whether you just go fully out there and say this is a race-conscious, race-based program that is about curing anti-Blackness. You're going to have an equally difficult road to hoe, whether it's lineage or whether it's harm-based. And from that, with that said, one of the most important things, without getting too wonky, is to create reparations programs that show that the government has a compelling interest in eliminating these harms, and recognizing that, yes, at some point, there's going to be litigation about it, and you're going to have to meet that strict scrutiny standard. And so your program has to be very methodical. It has to be very much based on social science, because at the end of the day, you're going to have to prove to a court that the social science shows that the harm is continuing, that the harm is, and that the government has a compelling interest and it's necessary to finally eliminate these harms, regardless of whether you have a lineage-based construct or a harm-based construct. You are likely going to have to meet strict scrutiny, and you meet strict scrutiny by having a very, very strong methodology for your reparations program. I'll just end by showing you what the California Reparations Task Force methodology looked like. It is 1,100 pages of pure social science. It is 1,100 pages of qualitative and quantitative information that collects narratives, thousands, tens of thousands of narratives from Black people who are still undergoing that harm based on anti-Blackness. And it is also we had more than 100 experts in every single facet of science, social science, testify as to the continuing nature of the harm. And so we have an extremely sound methodology that we used that is strong enough to actually meet strict scrutiny and show that the government has a compelling interest. And any reparations program that you try to bring, expect it to get hit with strict scrutiny. So make sure that your methodology is sound and foolproof.
Thank you so much, Lisa. Maynard, we'd love to hear from you next.
Sure. I mean, there is just so much to discuss here, and I think Lisa hit all the key notes. Let me just say this and try to keep it somewhat short. You know, the 13th, 14th, 15th Amendments were all race-based passages, and so to say that we can't have remedies that are race-based it is appalling, and it's a slap in the face to Black people. Okay, the 14th Amendment, just to be clear, although it has some racial ramifications in it that afforded us some protections, I think the biggest problem with the 14th Amendment is it also took away our right to self-determination. It told us that we were going to be citizens. It did not give us a choice as to whether we were going to be citizens or not. So that's problematic. One of the things that we have to do as lawyers and scholars and academics and political scientists and social scientists is take the very Constitution itself and learn how to weaponize it against the very people that created it. Because as we know, what we're really facing here when we talk about the Constitution, strict scrutiny, compelling interest, does it violate the law, equal protection, and the courts will always rely on stare decisis and precedents. Well, if the history of the country has always been race-based and anti-Blackness, then we won't have the precedents and the stare decisis to make an argument, because the court can always say, well, the case before and the case before was always based on this, and we know the cases before certain landmark decisions were always anti-Black. And so the courts cannot, and we have to force the courts not to rely on, particularly the United States Supreme Court and the federal district courts, not to rely on their justifications of why they won't do something for us. That's the real key issue, because what it all boils down to is money and economics and power and keeping the status quo. And you're talking about, the problems we have when we talk about constitutional arguments and winning the day in court, from the White House to the church house, from Big Pharma to the Cosa Nostra, from the industrial prison complex to the industrial military complex. We have a problem fighting those, because what's going to really happen is once reparations is granted in its fullest manifestations, it's going to upset that economic status quo. It's going to upset that power status. Okay. And so because it does that, then we cannot let the courts get away with just the arguments of strict scrutiny, passing that test. Because if the 13th and 14th and 15th amendments were based on race as a remedy, then why can't the passage of laws today be race-based to create a remedy? You have a specific harm that was based on race, namely chattel slavery. Chattel slavery is a race-based harm. And so therefore, as Lisa said, pointing back to the 13th Amendment, you need to have a race-based remedy in the law that will create the remedies for Black people. They've done it for everyone else but us. Lisa said in the prior response to a question, the civil rights movement, the movement of the Black people have opened the doors for everyone else but us. And so when we open the doors for everyone else, we have to make sure that we hold it for ourselves and keep it for ourselves. It's going to be tough. It's going to be a fight, but we must do it. The legislatures can and are willing to do things, especially if we force the issue. The question is the courts, and we can't allow the courts to rely on antiquated concepts to keep the status quo, such as stare decisis and precedents. Thank you.
Thank you, Maynard. Safiwe?
All right, I'm going to make two brief points. The first one is I agree with Sister Nkichi about the Constitution actually enhances and helps us make our case. We have to remember that this was a wartime operation, the trafficking of our ancestors. Those 13 British colonies entered the war that at a particular time in history was under a monopoly contract with the British. These Asiento contracts in these British colonies entered the war when those states legalized the trafficking. Then, when those colonies became the United States of America, it was the Constitution and the founding of what we know as the United States of America that officially contracted and entered into that war when they allowed what? The continuing of the trafficking of our ancestors to continue from 1789 to 1809, right? So the Constitution, and this is something that Maynard's uncles, Amari and Gaidi Obadeli, right, already have put to the United States government, the various articles, sections, and clauses, right, where the United States Constitution is the war contract against our ancestors. So I believe that the Constitution helps us make certain arguments, especially when we change the narrative from a trade in slaves. It wasn't a commercial enterprise, and it didn't involve slaves. It was a military enterprise that involved trafficking of prisoners of war. My second point, and this is to kind of piggyback off of what Lisa was saying about, and the others, about the continuing harms. Well, guess what? The easiest continuing harm to show that goes to the very original harm is the lineage, right? We talked about the misconception. It's not just about a check. It's about repair, self-repair, internal repair, as well as external repair. Well, guess what? Before the crime happened, right, you knew your lineage. You knew your paternal lineage or your maternal lineage. If you ask the vast majority of our people today, right, what is your paternal ancestry or what is your maternal ancestry? They don't know. That's evidence of continuing ethnocide. Ethnocide is a crime. It's the cousin of genocide. But we've never used a legal strategy to say, look, there were all these people who knew who they were before this event happened. They don't know now. And when you check a box where you check your identity, which is a trademark, the terms Negro and Black do not refer to humans. They are what are called trademarks, intellectual property produced by the guilty party engaged in the slave trade to dehumanize us. So even today, when the United States government, knowing that the DNA testing is available and doesn't offer it to us and says, check this box, you are either Black or African American, that's continuing state-sanctioned ethnocide. And my final point is just to clarify, Sister Nkichi and I have this conversation. I'm not for using lineage as a way to disqualify people. I believe that instead of that being a mandate or a regulation, that should be one of the primary objects of reparations. We should be saying that, yeah, it's not just about a check. It's about understanding your true history. And part of the reparations demand should be providing the new 21st technology, the DNA testing, free, and make it available to anyone who wants it so that they can repair the lineage. I see it not as a disqualifying element. It should be an object so that when we talk about repair, that's a very central part of it.
Thank you so much, Sophia. We're going to go right into Q&A. I'm going to start with a question from Adjoa Ayatoro. And anyone feel free to jump in and answer. Is there a relationship between the eligibility for reparations and the ease or difficulty in providing it by the entities responsible to do so? Will the difficulty or ease the effect of likelihood of obtaining reparations? Should I read it again? Nikita, you're muted.
Yeah, I'm sorry. I was saying this absolutely, I feel there's absolutely a relationship between ease or difficulty. The easier something is, the more likely it is to be able to have it effectuated. I'd like to hear my co-panelists' views on that, but that's just my initial knee-jerk reaction to the question.
I'll jump in very quickly. It's a difficult challenge, and I think there is a relationship, a direct correlation. As I mentioned previously, you got to really look at the historical and future ramifications of what reparations will really do to what I call the world order of economics. And when you look at money, no one wants to cede money and no one wants to cede power. And so it's going to be a very difficult challenge, one that we will win. We shall win the war on this front when it comes to the right to self-determination and the right to reparations. And so, yes, there is a direct correlation between the two.
Very quickly, I just want to add that at the risk of sounding naive and simple-minded, it's very disingenuous, right, for the government. For 200 years, you prevented us from having education. You prevented us from having the capacity to keep records, to that now then require us to provide the records and documentation that you have.
And to make that a prerequisite. Anyone else? Okay, so I'm going to go into a question from Reverend Dr. Dale Snyder. What about the moral agreement to institutions and businesses who profited from our suffering to set the stage for reparations benefits? Are there any thoughts on that?
So again, I always say the harms from the enslavement era and beyond were multifaceted, thus the remedies must be multifaceted as well. The culpable parties were multifaceted, thus the duty to repair from those multiple parties are multifaceted as well. That's why I'm a proponent of reparations from the federal government, state and local governments, academic institutions, religious institutions, industries, corporations, private estates. I mean, I'm just so I forgot the question, but about when you first said it, that's what came off of my mind with respect to that. So thank you, Reverend Dr. Dale Snyder. They're from, I don't remember whether it's Pittsburgh or somewhere, the head of a historic church that's fighting for, land back.
Would anyone else like to answer the question? It is, what about the moral agreement to institutions and businesses who profited from our suffering to set the stage for reparations benefits? If not, we can go on to some other questions.
Just to jump in, ultimately, reparations are going to be paid through our tax systems, right? In some way, shape, or form. And so, if we have, we should be thinking about the importance of, instead of having a regressive tax system where institutions and businesses pay less money than individuals, which is what we have now, which is the reason why it's so critical to have a progressive tax system, right? So that big business who benefited from things like enslavement and Jim Crow are paying their share. But ultimately, the focus, I do believe, needs to be on the government, whether it's local or whether it is federal. The focus needs to be on the government, because the fact is, the government really they benefited from anti-Blackness, and they actually promulgated, they manufactured and cultivated anti-Blackness for hundreds of years in order to reap a profit from it. And so the onus of repairing that harm, and also the practical ability to repair the harm, really falls at the feet of the government, of the US government, and then local governments who also historically benefited and promulgated this harm.
Thank you. Let me see. This one is also for you, Lisa, but anyone can also answer. This question is from anonymous attendee. Can Ms. Holder explain how have courts interpreted the badges and incidents of slavery in past legal cases?
Here's the thing about the 13th Amendment. It's so, there's really a lot to it, but lawyers have not been very good at using it in their advocacy, right? The 13th Amendment has really been limited in modern times to cases where you have human trafficking, and often people, immigrants, being literally held as like a prisoner in someone's home, because people just think about it as the abolition of slavery in this very, very narrow sense, right? But they don't think about the legacies of slavery and how embedded in the text of the 13th Amendment, you're also, the Congress is also, has a duty and a mandate to create laws that prohibit those legacies of slavery. So we haven't done a very good job as advocates in utilizing the 13th Amendment expansively. And I think this reparations actually really gives us an opportunity now to grab hold of the 13th Amendment and wield it and weaponize it for eliminating all of these legacies of harm and legacies of slavery.
Thank you. Any other thoughts on this question? Okay, I'm gonna move on to the next one because we're actually getting through some. So this question is from Naomi Shaman. Do you see the prison abolition movement as part of reparations under the commitment to non-repetition?
One word, absolutely.
Okay. Absolutely. I assumed it would be yes.
And just quickly, from a historical perspective, that is how slavery transmuted, right? It transmuted from actual enslavement of people of African descent. Then it went to segregation, legalized segregation, in the form of Jim Crow. And then in this post-civil rights apartheid era, it transmuted to imprisonment, right? And we saw that happening in the early 20th century, when you saw the, basically formerly enslaved people being put into prison so that they could continue working as slaves, right? And people people use the exception clause of the 13th Amendment, right? That says except except when it comes to prisoners. slavery is abolished. They used that to continue to enslave Black people. We see it in the prison industrial complex, right? From the 80s on, in the mass incarceration, how that was really the new form of slavery. It was the new Jim Crow. So imprisonment and slavery and the carceral state have all been a huge mashup, frankly, since before emancipation, and they continue to sort of revolve around each other. So abolition in terms of the carceral state is also just critical to reparations and repairing the harm.
Thank you. Any other thoughts? So this is from V. Casanova Willis. How do we fully incorporate the human rights mandates with civil rights constitutional approaches to securing full reparations? Thank you for this essential work, in addition to accurately framing the catastrophic harm as a military operation versus trade. Is it possible to update our reparations work to reframe accurately as the criminal enterprise that this thing is updating in my face. Invasion, kidnapping, trafficking, rape, enslavement, genocide, as it was found in Durban, the crime against humanity.
Well, let me jump in here on this real quickly. First, I want to shout out to all of our activist professors who have been fighting in the international arenas, whether it's with CERD, whether it's at UN, the new permanent forum. We have a long tradition of freedom fighters demanding reparations that goes all the way back to the Paris Peace Conference in 1918, when both Marcus Garvey and W.E.B. Du Bois brought our reparations claims to the League of Nations, and they were denied. We have a long internationalist tradition, and I feel that it's growing in momentum. And my sister, Vicky Casanova, has been intimately involved, as well as everybody on this panel. And so one of the most recent sort of developments is this strategy that I've been working on, which is requesting an advisory opinion at the International Court of Justice. And the foundation of that is a reframing of the narrative. I'll just tell a story very quickly. When we were at the ACRA Reparations conference at the end of last year, Marcus Garvey Jr. Had made a comment, and he said, yes, at World War I, 20 million people died. In World War II, 50 million people died. In the Korean War, 10 million people died. In the Afghan War, 5 million people died. And in the transatlantic slave trade, 100 million died. And I had pointed out that why do we refer to the invasion and the death of our ancestors, 100 million? We refer to that as a trade, and everything else we refer to as a war. So the most important reframing of the narrative from a legal standpoint is documenting this was a declared war. It was a total war that has no statute of limitations. That means everybody that was trafficked is a prisoner of war. That means all the descendants that haven't been either finally released from jurisdiction through informed consent via a plebiscite or repatriated are descendants of prisoners of war and retain that status. These are new legal narratives that both CARICOM, the African Union, our own, forces are seriously considering and attempting to deploy now as a new arena of battle. So I'll stop there.
Thank you so much. We just went over time. We're supposed to end at 2:15. So I just want to thank everyone. And I wanted to give our panelists just an opportunity to give some very quick closing thoughts, 30 seconds or less, on what you feel is most important for people to understand about reparations and your stance on eligibility standards. I'm going to start with Safiwe so I can end with Nkechi. Safiwe, please give me your quick closing thoughts on eligibility standards, and then we'll go to Lisa.
So once again, I will reiterate that we need, in Nkechi's word, multifaceted, that we need all-inclusive eligibility criteria that is simple and clear. And we also should not make the mistake, while promoting that, discouraging people from also preparing their lineage claim if that can strengthen their claim. We should not frame it as an either or we're against it. We should be encouraging people, this can strengthen your claim, but it's not a requirement.
Thank you. Lisa, your thoughts?
I will say that, the harm begins with anti-Blackness, and the dismantling of the harm has to focus on the elimination of anti-Blackness. And also it is very important. I mean, reparations it's been around since emancipation. There's nothing new about this fight. But it's been most effective as a Pan-African movement, because it's unity in numbers, and it's also just a basic understanding of the historical truth that what we experienced in this country, our brothers and sisters across the globe in the diaspora were also experiencing, even on the continent, in the form of colonization. And slavery, Jim Crow, is just another iteration of colonization. And so you really have to have a deeper understanding historically of colonialism, colonization, to really effectively enter into this conversation.
Thank you. Maynard, your closing thoughts?
Sure. It definitely has to be very inclusive. The harm is broad. The remedy must be broad. When we figure out how to defeat racial capitalism, we'll win the war for reparations.
Thank you. Nkechi, your closing thoughts?
I just want to say that we are history in the making, and that history is equal parts. It's edgy, it's exciting, it's transformational, it's confrontational, it's messy, it's confusing, but it is happening right here, right now. And we need to come together as an African family and discuss and debate these issues and come up with a collective decision. It is a height of pomposity for one person or one organization to pronounce just what it is going to be. It is for all these ideas to come together and us to sift through them, and as a people, okay, we'll go with the plebiscite or whatever it is, as a people determine which way it is that we want to go, because only we can determine just what reparations is going to be. We, not the colonizer, not the oppressor class, but us, the injured party. So I want to throw it back to you, Jam, and because you've been very much a thought partner in all this. If you have any closing words also with respect to this discussion.
I just want to thank all of the panelists. I feel like I've learned so much throughout this discussion, and I really want to do a deep dive into the 13th Amendment now and just kind of learn all I can, because I think I've been over focusing on the 14th Amendment, and now I'm like, oh wait, and I do like the idea of focusing on something that is more expansive and give us the capability to imagine and innovate and be forward thinking in the reparation struggle. So I'm really excited about that, and I would love to pull from all the different thoughts and ideas here on eligibility, because I really think they bring us closer to obtaining comprehensive reparations, again, going beyond that check, but having a more holistic reparations. So I really appreciate all the panelists here today. I want to thank all of the attendees for attending the Reparation Information Thought Series, co-hosted by the Reparation Education Project and the National Black Cultural Information Trust. And all of you will, and yes, it was over 100, almost 200 RSVPs, over 100 attendees. And all of you that RSVP'd, even if you weren't able to attend, will get a copy of this video shortly. So be on the lookout for that, and be on the lookout for upcoming Reparation Information Thought Series webinars. Thank you very much, and have a great week.